Madam President, I'm here to respond to the nomination of Stephen Bradbury for a senior legal position in the United States Department of Transportation. I've had some experience with Mr. Bradbury, and in my experience, he is disqualified from serving in a legal government position of trust, such as he's been nominated for. The Bush administration pursued a policy of detainee mistreatment that since has been acknowledged to include torture of detainees. And the process that got the United States of America into a place where it was torturing detainees was a legal process that was full of mistakes and failures by the Office of Legal Counsel at the Department of Justice, by Mr. Bybee, by Mr. Yu, and by, following them, Mr. Bradbury. Let's start with just a word on the Office of Legal Counsel. Within the Department of Justice, the Office of Legal Counsel is seen as being the best of the best. The Department of Justice prides itself on attracting and training and perfecting the skills of the best lawyers in America. And as the United States Attorney, I had the privilege of serving with a lot of absolutely spectacularly skilled lawyers and trial advocates just in the small Rhode Island U.S. Attorney's Office, and of working with others from the Department of Justice. And I have just a very, very high opinion of Department of Justice lawyers and Department of Justice lawyering. But even within that expectation that Department of Justice lawyering will be first rate, the Office of Legal Counsel is supposed to be a cut above. These are people who go into that office with the possibility that they'll become United States Supreme Court justices. These are people who come out of clerkships on the United States Supreme Court, one of the highest academic achievements a law student can have, and end up joining the Office of Legal Counsel. So the Office of Legal Counsel ought to be held to a very high standard. And what happened when the Office of Legal Counsel was asked to take a look at the CIA torture program in the Bush administration was that it fell down or rolled over in virtually every respect. The factual investigation into what the CIA was actually doing was weak and ineffectual. The legal investigation into the past, into precedents, was, as I said in previous speeches at the time, fire the associate quality legal work. And it's particularly bad coming from the Office of Legal Counsel, because Office of Legal Counsel is supposed to be, as I said, the best of the best. It's hard to say that these guys failed having tried their best. They just weren't smart enough to figure it out. They just weren't hardworking enough. They just didn't know enough about legal research or scholarship. So, nice try, but, you blew it, but, no harm in it, because we don't expect much of you to begin with. That is certainly not the case with OLC. The array of memos that the OLC wrote, the Bybee and Yu and Bradbury memos, were a calamitous failure of historical and legal research. For one thing, they failed to recognize and report that there had been prosecutions of Japanese military officers after World War II for torturing American soldiers. And one of the techniques of torture for which those Japanese soldiers were prosecuted and convicted as torturers, as war criminals, was use of the waterboard. Now, you may be able to say that there were some different justifications. You may be able to say that there were some different circumstances. But to not even mention that, to not even do the research to find out that that had taken place, that's a pretty bad legal failing. One of the reasons was they kept it so close hold that they didn't let military lawyers know what they were doing. Now, one could argue that there's consciousness of guilt there, that they didn't want other lawyers to know what they were doing because they knew what they were doing was shoddy legal work and they didn't want to be caught out in it. And in fact, ultimately, a lot of those opinions were withdrawn. But the fact of the matter is, it was a failure to properly inform the President of the United States about this history of our country actually prosecuting Japanese soldiers for the type of conduct that the Department of Justice was approving that the CIA engage in. It wasn't just prosecutions of Japanese soldiers by American military tribunals. There were also prosecutions of American soldiers in the Philippines by courts martial for torture. And guess what? The conduct involved was waterboarding. Now, again, perhaps you can say there were some differences, there was some distinction, but the fact is that in memo after memo after memo after memo, including the wrap-up memo that Bradbury wrote, that was not discussed. It was not disclosed, and it was not discussed. Now, you may say, well, you know, it's asking an awful lot of the Office of Legal Counsel to go and look at history, to go and look at the practice of our military in prosecuting adversary officers or in prosecuting our own soldiers. After all, we're just the Department of Justice, that's the Department of Defense. What could we possibly learn from that? Well, obviously that would be wrong, and obviously that would be a mistake, particularly when you look across that boundary to military law and see these examples right on point that they did not bother to discuss or disclose. But then it gets better still. The OLC memos failed to disclose prosecutions by the Department of Justice for waterboarding. Not some case that never got reported someplace that was just a trial and you'd have to look deep into your own records to try to find what took place, perhaps without a reported decision, just a verdict from the jury. This was a case that was extensively documented with writings by the trial court judge, a United States district judge in the state of Texas, that went up on appeal to the Circuit Court of Appeals. And the United States Circuit Court of Appeals wrote a decision on appeal of the district court's decision. What were the facts? The facts were that there was a local sheriff. His last name was Lee, so the case was named United States versus Lee. And Mr. Lee had gone into the business of waterboarding prisoners, strapping them in a chair, tipping them back, and pouring water over their faces to give the illusion of drowning. The court's decision over and over describes this conduct as torture. If you use legal search tools and look for the words water and torture, United States versus Lee comes up. And it's a circuit court decision, Circuit Court of Appeals. How could they miss it? How could they miss it? Well, there are only two explanations that I can come up with. One is that they really did a shoddy job of workmanship, that they didn't bother to do basic legal research. That's why I've described this in the past as fire the associate quality work. If you haven't done the basic legal research to determine what the cases are on point on the question whether the use of water on bound prisoners is torture, you haven't done much of a good job. The problem is that that scenario is actually the best case scenario. The best case scenario is that they did such slipshod work at the Office of Legal Counsel that they didn't find a United States Circuit Court of Appeals decision on point to the question upon which OLC was advising the President of the United States. That's the best case scenario. The worst case scenario is that they did find it. They did find it and decided not to talk about it in their memos. Because you can read United States versus Lee and put it against those OLC memos, and I think any rational reader will find them impossible to correlate. There is a real possibility that the Office of Legal Counsel decided that because Cheney had decided on this torture program, because they were embarked on this torture program, they were going to have to deliver the legal opinion that allowed it to continue, and if it meant ignoring a case that proved their opinion wrong, they were going to ignore the case, and they were going to go ahead with the opinion. As you can imagine, that's considerably worse than simply not finding the case. We've never had a very good description of how this all came out. There was an OPR report from the Department of Justice that heaped condemnation on the various players here. But ultimately, this question of what the obligation is of an OLC lawyer to fairly disclose what the relevant case law is in writing an OLC opinion was never reached. It was never reached because at the end of this long and arduous process, the Department of Justice made, I think, a terrible decision. There's a rule of professional conduct. It's called the rule of candor to the tribunal. If you're a lawyer and you're going before a judge, you have an obligation to state the law fairly and accurately to the judge. If you're not being truthful to the judge about what the law is, that's a violation of professional conduct for which lawyers can be sanctioned. And it applies to lawyers across the board. A hardworking lawyer with 6 or 7 files under his arms, piling into a state district court to maybe run through 3 or 4 cases in that day before a busy judge, that lawyer has the obligation of candor. And it includes an obligation to do adequate research, to actually have looked up the case law and to disclose it to the judge so that you're not misleading the court about the state of the law. That applies to lawyers across the country. The busiest, the most distracted, just local lawyer, just a guy with a practice, maybe in a strip mall, who buzzes into court with a bunch of files under his arms, that lawyer is under that same obligation. But the Office of Legal Counsel, this high temple of lawyering, this best of the best at the Department of Justice, the Department of Justice made the decision that those lawyers, in providing advice to the President of the United States, did not have the same obligation of candor that an ordinary day-to-day working lawyer in a local courthouse has to that local judge. I believe that rule has since been reversed, and I think it's very good that it has been reversed, because I think the President of the United States is entitled to at least the level of candor from these best of the best lawyers at the Office of Legal Counsel than a local judge is from the hard-working, overburdened, day-to-day lawyers who appear in front of him or her. But that's not what the President got. Not from this Office of Legal Counsel, not from Steve Bradbury. So, again, I don't know that we'll ever know, because that decision from the department put to an end investigation into the question of whether this failure amounted to professional malpractice by the OLC lawyers. But the options aren't great. These lawyers either didn't do the work to discover the military tribunals, the courts martial, and the Texas criminal prosecution by the Department of Justice, or worse yet, they did discover those things and deliberately withheld that information so that they could give the opinion that they thought they were supposed to give. It's about the worst thing that a lawyer in that position could do. And until that's cleared up, I cannot possibly support the nomination of Stephen Bradbury to any position of trust in the government of the United States. With that, I yield the floor.